There are a number of legal implications of 3D printing and other localised manufacturing issues. There are always legal implications in whatever we do. New technologies bring particular challenges, and it brings a challenge to the law to adapt to fit in with how that technology presents itself. With 3D printing in particular, there are a whole host of intellectual property issues. I think those probably come at the forefront, and there are a series of complicated issues because of the different way that 3D printing presents itself to manufacturing. There are also product liability issues. There are a whole host of different people that get involved in 3D printing, and then the traceability issue is a big problem there. In addition to that, there frequently, once you get any form of connectivity going on, there's going to be data, big data, personal data, and that brings its challenges as well. There may even be issues around employees who are using 3D printers, who are connected in some way, and how actually they should operate, their personal data gets used, how they're monitored. So you can see that there are a whole host of legal issues we can grapple with. Yes, so there are a number of intellectual property issues. I think the first thing to consider is copyright, because there are different stages in the 3D printing process. And if we go right back to the design, the CAD design that is used, you've got copyright in that design. So actually reproducing and distributing that design, you've got a copyright issue going on there. Once you come through to actually printing the product, you've got copyright issues in materials that might be printed on the surface. If they amount to artistic works, you've got copyright issues there, such as jewellery, pottery items, etc. Those will attract copyright. And if we move slightly away from copyright into the design field, again, there are unregistered designs, there are registered designs, all of which have to be taken into account when reproducing products of any kind. And it's not just designs, we go into the patent side. Patents protect various inventions. So again, it is perfectly possible that in reproducing a product, you can actually be infringing somebody's patent, and merely keeping the product is an infringement of that patent. And we mustn't forget trademarks. Again, trademarks have their place to play in this. So if you, for example, reproduced a product with the trademark on, then that in turn could amount to trademark infringement. And a form of unregistered trademark infringement, if you're producing products that people believe have come from the original designer, that can amount to passing off as well. So you can see there are a whole host of intellectual property issues that you need to be aware of in order to take account of them in 3D printing. If you think about manufacturing an item such as a bicycle helmet, the design is actually made available for somebody to produce it, and then they produce that at home, and then they use their helmet, and there's an accident, and the helmet is in some way defective, it cracks. So whose responsibility is that? So should we go back to the original manufacturer who produced them elsewhere but didn't manufacture this particular product? Should we go to the designer of the helmet and say that they're responsible for the design? Should it be the producer of the 3D printer itself? Should it be the person who supplied the materials in order to produce the helmet? Or should it be the individual who actually put the instructions in to produce their own helmet? A whole host of different people who could have responsibility. And then you've got the traceability issue. Well, where did the problem arise? So you have to sort that out. And again, it comes down to working out arrangements, contractual arrangements, disclaimers, and then possibly insurance as well, to make sure that you do have the cover that you need in that sort of instance. I always believe that the law should be there to enable, not to stand in the way of development, and that's particularly important in the intellectual property area, because intellectual property started with the idea that it encouraged people to innovate. So the last thing we want is to use any form of law, particularly intellectual property, to block that. But what is really important is that the lawyers actually understand what's going on in manufacturing, get to grips with the actual technology so that we can apply the complex areas of law to the technology and make sure it works for everybody. And it's not just going to be about looking at how the law actually works in relation to the particular 3D printing and the other connected technologies around it. It'll also be a question of looking at the different contractual models that should apply, because the whole connected manufacturing piece means that we're moving into a different sort of contractual arrangement. So, for example, the traditional owner of intellectual property around the product may be manufacturing and just selling the product. Going forward, they may be needing to look at licensing and collaborating with more people. So again, I think we have to be quite innovative ourselves as lawyers to create the legal models that will work with these developments.